As we just reviewed, damages are broken up into two major categories. The first category is economic damages, which is wage loss and medical bills. The second main category of damages are what are called non-economic damages, or what we call human damages. Non-economic damages are comprised of categories such as pain and suffering, mental anguish, loss of the enjoyment of life, inconvenience, significant scarring, aggravation of a pre-existing condition. And this can be a tricky part of an automobile personal injury claim, and here's why. The law in the state of Florida is that in an automobile claim, if you've been hurt in an automobile accident, you are not entitled to non-economic damages, any of these categories, pain and suffering, mental anguish, loss of the enjoyment of life. You're not entitled to any of those unless you have suffered a permanent injury. So, what is a permanent injury? Permanent injury is when you have healed as much as you're going to heal. It's called maximum medical improvement, and you're not back to where you were before. If you were pain-free in your back or your neck or your shoulder or wherever your injury is before this collision, and you've gone through the medical treatment with the medical providers and the doctors have placed you at what's called maximum medical improvement, meaning you're basically as good as you're going to get, and you're not back to wherever it was that you were before this collision, then you can submit your claim to a jury that you've suffered a permanent injury from this collision. If a jury finds that you have not suffered a permanent injury, then you're not entitled to anything for pain and suffering, mental anguish, loss of the enjoyment of life, inconvenience, significant scarring, or aggravation of a pre-existing condition. You would still be entitled to your economic damages, which is wage loss in the past and in the future, and the medical bills in the past and the future. So it's very, very important, again, to treat with your doctor and let your doctor know the truth about your injuries. And remember this, when you're treating with your doctor needs to put your complaints in the record. There's an old saying under the law, which is, if it's not in the medical records, it didn't happen. And what that means is this. I like to compare trial lawyers are like professional gamblers. And like every professional gambler, we're only as good as the hand of cards that we're dealt. And as far as trial lawyers go, our hand of cards is made up of your medical records. And if it's not in those medical records, we can't play those cards. So again, it's very important that you tell the truth, and we're not for a moment suggesting that you're not always completely truthful with all medical providers. And we'll talk more about that in just a few minutes. But it is important that you not just tell your doctor that you're in pain, but how you're in pain. What kind of pain is it? Is it electric pain? Is it radiate down your extremities? Is it a throbbing pain? Does it change later in the day from earlier in the day? Whatever the truth is, it's very important that you tell your doctors, because your doctors have to put that in the records for us to be able to use that information to your benefit in your legal case. And once again, if the jury finds that you have not suffered a permanent injury as a result of this collision, then we're not entitled at all to any of the non-economic damages, which again are pain and suffering, loss of enjoyment of life, mental anguish, inconvenience, and aggravation of a pre-existing condition. Now, why do they call those non-economic damages? They call those non-economic damages because if your case goes to trial, and we work every case as if it's going to trial because we know that's how to get the most value for your case, and I'll explain to you in a few more minutes why that is. But the point is that we know in working cases up for trial that the non-economic damages are hotly contested by opposing counsel and by insurance companies, because they add up to potentially millions and millions of dollars. Why? Because each one of these categories are separate and distinct. And the judge will read an instruction to the jury that there's no precise formula that a jury has to use when determining non-economic damages, that the damages should be awarded by whatever is fair and just in light of the evidence. So we will suggest an hourly figure. And if you say $5 an hour for pain and suffering, and another $5 an hour for loss of enjoyment of life, and another $5 an hour for mental anguish as you go down the list, and then however many hours a day times 365 days a year times however many years in your life expectancy, you can see that this can add up to a great deal of money. So this issue of permanent injury or not is hotly contested by insurance companies, and they know how to fight. And so it's very, very important that you understand the concept that even whether or not you have a permanent injury, even if you don't have a permanent injury, you're still entitled to your economic damages, which is your medical bills and your wage loss, but you would not be entitled to any of the non-economic damages. It's very important that you understand this critical aspect of your case, and if you don't, ask us questions.